Okay, well, thank you all for having me here this afternoon. I have my Madonna microphone on because I like to move around when I'm talking. I don't quite like to stand behind the podium. And please, if you have any questions that you think would be better answered as I'm going through, please don't hesitate to shoot up a hand. I'm happy to answer questions as I'm going through. Now, it's my understanding that we have physicians here from New Jersey, Florida, and Pennsylvania. Is that correct? Because you have HIPAA requirement for your CME. What we're going to do is just go through the basics. And also in 2013, there was a major overhaul of the HIPAA rules. So we will go through some of the changes that resulted from that overhaul. And hopefully, all of your practices have addressed them already. So basically, what is HIPAA? A lot of people refer to HIPAA. A lot of people aren't really quite sure what it is. A lot of times, we'll have patients saying, well, isn't this against HIPAA? Isn't that against HIPAA? When it's really something that maybe doesn't really have anything to do with HIPAA. They just know it has something to do with their rights as a patient and their privacy. HIPAA is a collection of laws and regulations. And these laws and regulations basically dictate what a patient's rights are with regard to their private medical records, and what a physician and a medical practice's obligations are with regard to those same medical records. The actual law is the Health Insurance Portability and Accountability Act of 1996. And what that law did was that law authorized the department to produce rules, including the privacy rule, security rule, and breach notification rule. And just in case anyone's interested in some light reading, I did put the citations for those rules there as well. The Health Insurance Portability and Accountability Act, or HIPAA, was passed in 1996. It was, like I said, passed to have DHSS generate these rules. And it also mandated that states adopt these federal rules. Now, something very important about that. HIPAA is federal. I do advise people that I can advise on HIPAA, and I'm happy to advise on HIPAA throughout the country because it is federal, so I'm not restricted in that way with regard to my state licensure. But what you do need to be careful of in your own state, HIPAA rules are paramount unless your own state has rules that are more strict. If your own state has rules that are more strict, then you do have to abide by that higher level of the state rules. HITECH is a sister law for HIPAA. It was passed in 2009 as part of the American Recovery and Reinvestment Act, or the Affordable Care Act, and it was intended to promote the adoption of meaningful use of electronic records. I'm sure many of you in this room have been going through the adoption of electronic medical records in your practices, or in your facilities where you work, you've been part of that. One of the fields where I was working quite actively last year and the year before was assisting practices with appeals of meaningful use audits and responses to meaningful use audits. Because of course, the government gave you the incentive money and then they looked for every possible way they could to take it back. So we did a lot of that work. Now we're not really seeing that so much anymore because the incentives have expired, or people are in their final years of getting the incentives and they've kind of gotten the hang of what they have to produce to secure those funds. What HITECH also does is it addresses penalties for violation of HIPAA with electronic health information. Now, I was actually speaking with somebody in the exhibit hall. I'm not sure if it was on Thursday or Wednesday, but we were having a lively discussion about electronic records and HIPAA. And I had actually said that knowing what I know, I really love when I go to my doctor and they still pull out a paper chart. So, you know, anyone who's still using paper charts, if you practice in northern New Jersey, let me know. Because I just, knowing what I know about the internet and electronic records and now how they're pushing for interoperability, which basically means not only are your medical records going to be on a computer, but they're going to be online. My feeling is it's not a matter of if you're going to have a data breach, it's a matter of when you're going to have a data breach and whether or not you're prepared for that data breach. Now, the privacy, security, and breach notification rules, these were originally 3 separate rules. privacy, that establishes the set of the national standards for protection of patient health information. The security rule, that establishes the standards for protection of that health information that's stored electronically or transmitted electronically. And what a lot of people don't realize is even if you're using paper records, if you fax a record to another provider or anything of that nature, that you would still be subject to the security rule because you're doing an electronic transmission of a record. And then the breach notification rule, that's basically the rules by which you would have to abide if you did discover that you had a breach. Who do you have to notify? What do you have to do? How do you have to mitigate the damages of that breach? Now, in 2013, the government came out with, ready? The HIPAA Privacy, Security, Enforcement, and Breach Notification Final Omnibus Rule, which we just affectionately refer to as the Omnibus Rule. And what that did is that basically combined the old privacy, security, and breach notification rules into one big rule. One of the things that I did when this rule was passed in the firm where I was working at that time, one of my jobs was to go through that rule with a fine-tooth comb and come up with advice for our clients as to what needed to be updated, how it needed to be updated. So unfortunately, I can almost recite this omnibus rule in my sleep. I don't recommend it. Changes under the omnibus rule. There are some significant changes. If you have not updated your notice of privacy practices or your business associate agreements since 2013, you do have a problem. If you don't know what a notice of privacy practices is or a business associate agreement is, then you have a big problem, and we should probably talk. But if they have not been updated since 2013 under the omnibus rule, you are going to have a problem. Notice of privacy practices. I'll explain a little bit more the basics of what a notice of privacy practices is as we go on. But essentially, that's the form that you're going to give out to all your patients when they come in. It's posted on the wall in your waiting room. If you have a website, it's on your website. It explains to them how you're allowed to use their medical information, and it explains to them how they're allowed to access their medical information. The notice of privacy practices changes under the omnibus rule. There are new explanatory statements that have to be in that notice. Specifically, some examples regarding sale of PHI, which is protected health information, if you see that abbreviation anywhere, marketing use of PHI, and research use of PHI. Those are really the big three changes. And again, like I said, those changes must have been incorporated into your notice of privacy practices prior to September 23rd, 2013. So if anyone did not make those updates, that's something you want to make sure you pay attention to very soon. And the definition of the business associate, now how many people know what a business associate is? Okay. All of your medical practices are what's considered a covered entity. The covered entity is the actual entity that is covered by HIPAA, that receives the health information, generates the health information, produces the health information. A business associate would be someone like me. Okay, your medical practice hires me, hires an attorney to come in. One of the things I do is I'll go into practices and I'll basically do a site visit and an evaluation and say, okay, here are the 4 things you need to do to come up to speed with HIPAA. What that typically involves is I'll be looking at patient records. I am now a business associate. Any third party that you hire to provide a service for your practice, and part of that service is more than just an incidental chance of exposure to patient medical records, that person is a business associate. What that means is you need a written agreement between your practice and that third party that you're hiring, which obligates that third party to abide by HIPAA in the same way that you would have to abide by HIPAA. So that's the first and business associate agreements have always been a requirement since the original HIPAA. What's changed now under the omnibus rule is now that goes downstream even further. Let's say you hire me to do something for your practice that has to do with patient records, and I work with a subcontractor. Not only do you have to have a business associate agreement with me, but that business associate agreement has to require me to have an agreement with any subcontractors that I might hire to work on whatever I'm working on for you. And again, any business associate agreements that were in place were grandfathered prior to January 23rd, 2013, but as you could see, we're also well past the date where those needed to be updated as well. Any that were grandfathered, we're at the point where those needed to be updated too. So like I said, at any subcontractors, now people have asked me, okay, well, you know, we have someone come in and clean the office every night. That person is not a business associate. Because that person, first of all, your patient records are supposed to either be on computers that are shut down and password protected, or in cabinets that are locked when they're not in use. So that person should not be able to access any of your patient records. If for some reason a piece of paper or something is left out, that's what's considered an incidental and unintentional access. And chances are that person's not even going to look at it. They're just going to put it on your desk, put it on the reception desk. So there's a very, very low chance that anyone's actually going to do anything with those records. So that's the type of subcontractor or third-party contractor that would not be included in a business associate. More changes under the omnibus rule. Of course, there are enhanced penalties. The government likes to enhance penalties. They do it often. And breach has been redefined to include a presumption that an impermissible use or disclosure is a breach. Previously, if you thought you had a breach, there was an analysis that you went through, and unless that analysis resulted in the outcome that, oh yes, this was a breach, then you did not have to report it as a breach. Now there's a presumption that you had a breach, and the analysis has to show that there was not a breach. There was that previously used analysis was called a harm analysis. Now there's a 4-factor risk analysis, which I'll talk about in a couple minutes, more of the details of what that is. There's a prohibition now on health plans using or disclosing genetic information. That drives me nuts because it's called Gina, and my name's Gina, and it gets a little bit crazy when I'm talking to people about that. They don't know if I'm talking about myself or the law, but that is a restriction on disclosure of genetic information. And there are now separate authorizations required for different kinds of protected health information. One of the number one problems I see when I go into medical practices for regulatory consulting and advice is insufficient authorizations for release of medical information, and also the lack of separation of different kinds of authorizations. Now we're going to go through each of these basic requirements under HIPAA, and now you can assume everything I'm talking about going forward is under the new HIPAA, the omnibus rule. Notice of privacy practices, uses and disclosures of protected health information. When is an authorization required? When is it not required? Privacy officer. How many people have a designated privacy officer in their practice? Okay. How many don't know if they have a designated privacy officer in their practice? Okay. You should all have a designated privacy officer in your practice, and you should all know who that person is. Patient access to protected health information. Okay, what are they allowed to access? What are patients entitled to? And what are they allowed to do with their medical records? Administrative, technical, and physical safeguards. Those are your 3 categories of safeguards of medical records that are required. And then business associates, like I said, we'll get a little bit more into what business associate relationships are all about. Notice of privacy practices, okay? As I said, all covered entities must have a written notice of privacy practices. Now, how many of you have a written notice of privacy practices? Okay. Now, how many of you know that it's been updated since 2013? Okay. If it hasn't been updated since 2013 or you're not sure, it's definitely something you need to take a look at. The notice of privacy practices has to explain in detail to the patient how the covered entity can use and disclose their protected health information. That's typically the top 3 are treatment, payment, or healthcare operations. Those are the 3 key phrases to remember. You do not need an authorization to disclose patient information for treatment, payment, or healthcare operations. Patient's rights as to his or her protected health information, that's basically the part of the notice of privacy practices where you say you have a right to see your patient record, you have a right to copies of your patient record, but these are the limitations on that, and this is how you have to request it. And in certain situations, this is what you have to pay us for it. And then the covered entity's obligations as to the patient's protected health information. That's basically obligations such as, this is how we have to store your protected health information. In New Jersey, the Board of Medical Examiners requires all patient records to be kept for a period of 7 years from the date of the last entry in the record. Some insurance companies require a longer period than that, and I apologize, I don't know off the top of my head what the time limit is in Florida or Pennsylvania. But I do know in New Jersey it's 7 years, and a lot of times I will have physicians say, oh, well, I'm retiring, so I'm just going to shred all the patient records. Can't do that. Even if you are retired and you're closing your practice, you still need to account for the maintenance of those patient records and that protected health information for 7 years from the date of the last entry in every one of those records. I actually recently had a client who had been in practice for quite some time. I mean, this was his private practice for basically his entire career, and he had never gotten rid of a patient record. And part of his retirement plan was selling his practice to the hospital. And a huge part of the negotiation was who's going to go in there, and these were paper records, who's going to go in there and cull through all the paper records to determine which ones need to be kept and which ones can be shredded. And thankfully, we ended up negotiating that the purchasing party would have to do that because I had no idea how my client was going to be able to handle it by himself. But you don't have to, that's another planning. If you do have paper records, you can get rid of a lot of the bulk. If you haven't seen a patient in 10 years, you're no longer obligated to keep that record. Other information that has to be in the Notice of Privacy Practice, other obligations with regard to the Notice of Privacy Practices. The notice has to be provided to every patient on their first visit. The patient must sign and acknowledge that he or she received that notice, and that acknowledgement should be kept in the patient chart. Now, what I recommend is you give the new patient a copy of your Notice of Privacy Practices, and you simply have them sign and date a second copy, and you put that second copy that they signed and dated in the patient chart. I do know that there are ways to accommodate for that in electronic records. I have to be perfectly honest with you, I'm not sure what they are. But the electronic record individuals that I have worked with from those companies say that they do have ways of importing those documents and having you have a patient sign off that they've received it. Now, the patient, they don't have to sign that they've received it. That's best practices. But if you do have a patient that for whatever reason says, you know what, you gave me this Notice of Privacy Practices, but I just don't feel like signing and telling you I received it. At that point, if you're still comfortable treating that patient, all you would have to do is just make a note in the record that you did provide it to them, and they simply refuse to sign an acknowledgement that they received it. That is sufficient. The reason why I suggest that you just have the person sign a copy of whatever they received is because part of the obligation is you do have to note which copy of the Notice of Privacy Practices they received. So in my experience, that's the easiest way to do it. Another obligation of Notice of Privacy Practices, they have to be posted in your office in an area accessible to patients. The most logical place is the waiting room. If you go into any doctor's office at this point, any hospital, you will see the Notice of Privacy Practices on the wall. If I'm ever in any of your offices, don't make me wait too long because I usually end up reading it and making notes in my head about the things that need to be updated. And that's never a good idea. But usually that's posted in the waiting room. And then another problem I see a lot, many medical practices now are developing websites because let's face it, if you're not on the internet, you don't exist. You need to make sure that your Notice of Privacy Practices is on your website. And can't tell you how many times I've had new clients come in, and for whatever they're hiring me for, I'll go on their website, get a better idea of what they do, what their practice is like, and the number one conversation we end up having to have is, your Notice of Privacy Practices isn't on your website. You need to get that up there ASAP. Okay, after that first initial time that you provide the Notice of Privacy Practices, after that, just keep a stack of them at the front desk. If any patient comes in and asks for a copy, even if it's available online, if they ask for a hard copy, you have to give it to them. So you can't just say, sure, you can have a copy, go online, download it, print it yourself. you have to hand them a hard copy. And then the notice of privacy practices also has to include an effective date. And as I said, at this point, everyone's effective date of their notice of privacy practices needs to be after September 2013, or else it's out of date. When you update that notice of privacy practices, you do not have to redistribute it to every patient. It's perfectly fine that they have the original notice that they received, even if they've been your patient for 20 years, and they received their original notice in 1996, that's fine. You don't have to distribute another one to them. You don't have to have them sign a new acknowledgement. Just make sure you update what's posted and you update what's on your website. Now, one of the big things, the big pieces of information that's going to be given to patients in that notice of privacy practices is how can you use and disclose their information, and how can they get a hold of a copy of their information. And they would get a hold of a copy of their information if an authorization is required using one of three authorizations. The most common is a general authorization for use and disclosure. That's basically, it doesn't fall into any of the two next categories I'm going to talk about, but you do need written authorization to get it. You could also have an authorization of use or disclosure of psychotherapy notes. If anyone practices in a field or practices with someone who practices in a field that does psychotherapy with patients, psychotherapy notes always have to be segregated from the rest of the patient record, and you will always need a separate authorization specifically for those psychotherapy notes. Even if you have an authorization for the rest of the record, those notes do not get released unless you have the specific authorization. And then the last one, which was a big update under the omnibus rule, was authorization for use and disclosure for marketing purposes. And a lot of this comes, along with the idea that, they want to reduce the reach that drug companies have, supply companies have, things like that. And that basically means that you need to have your patients authorize if they're willing to receive communications about a product or a service that encourages the purchase of the product or the service. And you'll see down there are specific exceptions. They're all up there for you, so in the interest of time, I won't also read them to you. A valid authorization must be written in plain language that the typical patient can read and understand. This always kind of makes me laugh a little bit because it has to be written in plain language, but then you'll see there's a list that goes down the rest of the page of what that authorization that's in simple language that somebody can easily read and understand must include. A meaningful description of the information to be used or disclosed. Although that's a requirement, somebody can just say, my whole record. That's a meaningful description. And the name or specific identification of the person or the entity authorized to make the use or disclosure. That's, for example, you can disclose my medical information to my attorney. You can disclose my medical information to the next doctor that I'm going to see because for whatever reason I had a change in insurance. I can't come see you anymore, something like that. Okay, other specific identification information, a description of the purpose at the request of the individual is sufficient. If somebody simply says, and what I actually advise my clients to do on their authorizations, because 9 times out of 10, people think all the blanks are optional, and you're going to be lucky if you get them to fill out their name and address and where they want the records to go. I just have a little caveat on there that says if you leave this line blank, then it's going to be understood that you just want them released at your request, at the request of the individual. Expiration date or expiration of event. This is an important one. If there's no expiration date for the use and disclosure, that's not a valid use and disclosure. A lot of times I'll have patients send over an authorization to me and say, hey, can I release these records? And I have to say to them, look, I don't mean to be a pain in the butt. I know that you have a close relationship with this patient and you know why they need these records sent, but there's no expiration date on this authorization. There's no description of the purpose. It's not a valid authorization. You take a big risk by releasing the records. Send it back to them, tell them you're happy to release the records, but you need them to update the authorization with these information. And then obviously signature of the requesting individual. And what a lot of people say is, well, they sent this to me in the mail. Anybody could be signing it. That's true. One of the obligations is that you have to, and it's vague, but it says that you have to take sufficient steps to make sure that that's really the person whose name is on there that's requesting it. That can be as simple as if somebody comes into your office and requests it in person, you just have your receptionist or whoever's at the front desk take a look at their ID, make sure it's really them. If you know the patient well, it can be as simple as calling them on the phone and saying, hey, I see that you're in litigation, and I got, and this actually just recently happened to me this week while I was here. I had a client emailing me back and forth papers. The other side, the other attorney on the other side of the case has produced a signed authorization for the medical records. I said, you know what? Just give the patient a quick call. Just make sure they really signed that authorization, because, you know, attorneys, you never know. So make sure they really sign that authorization before you send out those records, and make a note of it in the chart. Required statements, you do have to have a statement on there that the patient has the right to revoke their authorization. They have to do that in writing, and then any exceptions to that right. The ability or inability to condition treatment, payment, enrollment eligibility. In most scenarios, there is no right to condition treatment on whether or not someone signs an authorization, but there are some scenarios where there is a right to condition treatment on that authorization. If you are in one of those scenarios or in one of those categories of physicians or providers who has that right, you want to make sure that you have an explanation of the basis of that right on your authorization. And then finally, you have to disclose, there's a potential that the information disclosed, once it leaves you and goes to whoever the disclosing party is, or the party to which you're disclosing, that it's no longer protected by you, and that patient is now taking the chance that the person that the records are being sent to is going to protect those records properly. When is a written authorization required? See those 3 words again? Treatment, payment, or 6 words? 3 options. Treatment, payment, healthcare operations. If the disclosure is for any reason other than those 3 reasons, you typically need a written authorization. And then when the disclosure is not one that is otherwise permitted under HIPAA. So this is when you really get into the nuts and bolts of what exactly is said in the law, and you might want to, have someone that you can just call, or even have a cheat sheet in the office of these various different options. When is oral authorization sufficient? Informal permission, or what HIPAA refers to as the opportunity to agree or object, that's sufficient to allow disclosures for a facility directory of patient contact information. That's, for example, someone's in the hospital, a friend or a family member comes to see them, the hospital is allowed to tell them what room they're in and that they're there, or what their room number is, and let them call. Somebody's in a advanced care, a long-term care facility. Again, that's the ability of that facility to tell people that that person is residing there. Notification or disclosure to family, friends, relatives, only to the extent that person's involved in the patient care. What that means is you have a patient, and I actually see this a lot with my clients who are OBGYNs. They have young female patients that come to see them. They're paying cash. Mom or dad finds some type of medication or something, gets very upset, calls the doctor's name on the label, and says, I demand to know what my child came and saw you for. That parent is not otherwise involved in that patient's care, and that parent had nothing to do with the payment. So you're not allowed to discuss anything with that parent. Now again, I'm assuming this is young but over 18. There are different issues if the person's under 18, which are not part of this lecture. So that would be an example of notification of disclosure to family or friends. If you have, what we see a lot now is physicians that have elderly patients that are being cared for by their children, by their adult children. The adult child routinely takes that person in for their care, routinely speaks to the physician, is responsible for the payment of the co-pays, the deductibles, things like that. You can discuss the patient record with that person, but only to the extent it involves something that that family member is involved in or is paying for. And then notification of a school regarding students' immunization records, that's actually a big change. That's very important for people in family practice, primary care, internal medicine. You no longer have to have a written authorization to notify school about immunization records. Now you can just have an oral authorization from the parent or guardian or a student if they're over 18, and you just make a note of that in the chart, and then you can disclose to the school the immunization records. When is an authorization not required? Again, in the interest of time, I'm not going to read all of these for you. They're all out here in black and white, and it's my understanding that this whole presentation is online for you guys. But this is the pretty significant list of when an authorization is not required, and this is just when it's for public interest or benefit. And that's page 2. Okay, practice privacy officer. I think I saw like 2 hands when I asked how many practices have a privacy officer. All practices should have one individual who's designated the privacy officer. That individual is responsible for making sure that the practice meets all their obligations under HIPAA. That privacy officer should perform regular internal compliance risk assessment reviews, which actually, if you're going for meaningful use, are required under meaningful use as well, to prove that's one of, I believe it's prong, I think it was 15 of the meaningful use audits was to show that you did a compliance risk assessment, and conduct regular staff training on the requirements and implementation of HIPAA. Regular is not really defined. We don't know if regular means once a week. We don't know if regular means upon hire. We don't know if regular means once a year. I typically interpret it with my clients to mean once a year upon hire, and then once a year thereafter for their full staff. And I've never had anybody have a problem with that. Now, administrative safeguards. This is now where you're getting into what you have to do internally in your practice to protect those records. Security processes. Electronic security measures have to be implemented that reduce the risk and vulnerabilities of ePHI. That's electronic protected health information. Now, a lot of people will say to me all the time, well, you know, it's computers. It's impossible to protect against everything. Yes, you're 100% correct. It's impossible to protect against everything, and HIPAA does not expect you to protect against everything. But you have to show that you're taking reasonable measures to protect against as much as you possibly can. The security official, that's a designated person that oversees the implementation of these policies, makes sure that these policies are in place, makes sure that they're up to date as technology advances. For example, you might have an old policy from when you had 1 or 2 desktop computers in your practice, and now you have laptops, tablets, iPhones, things like that. All of these things are being used for your practice. Do you have updated policies to address that use? That's what your security official would make sure of. Information access. Individuals should not be permitted to access information that they do not need to perform their job. There really need to be measures in place to trace access, and this could just be as simple as a computer program that says, you know, this login logged in and accessed this patient record and they had no right, they weren't supposed to. A lot of times people will say to me, well, I don't know how can I be responsible for what my employees are doing? You have to be responsible for what your employees are doing with electronic PHI the same way you would be responsible for what they were doing with direct patient care. The same way that you wouldn't want a patient, going in and performing tasks for which they're not licensed or certified, you also need to make sure that they're not accessing records that they don't have any reason to be accessing. Where we get into this problem a lot is, so-and-so will be working in the hospital. They have no need to access the record of that certain celebrity that may or may not be in the hospital for a drug overdose, or something else that, regardless of whether or not they're in the hospital, they have a right to privacy to, but something like that could really be worth a lot of money, a lot of notoriety. In this day and age of people going online and making 5-minute videos and they're famous, a lot of people seek out that information. That's something that you really need to guard against. You can either do it by having technological safeguards in place where people with certain logins simply can't access that information, or if you don't have that, you need to make sure that it's all traceable, so if you do have a breach or a leak, you know where it came from and you can take care of it. That's what HIPAA expects. Training, I mean, we've gone through that. There has to be training and supervision, and evaluation, periodic evaluation. And again, periodic is not defined, but I've defined it with other practices that I've worked with to be approximately once a year. And again, I haven't had anybody have any issue with that. Technical safeguards, that's your access control, passwords and logins only for those who need it. Audit control, hardware, software, procedural mechanisms. People should not be using their personal electronic devices for work. If they need an electronic device for work that's going to have any kind of patient information on it, that should be something that's provided and controlled by the practice. Integrity controls, procedures to ensure that the EPHI is not impermissibly altered or destroyed. For example, that would be, again, you have the person who works in your practice and, you know, say they have a friend that comes in for a problem that they don't want their parent knowing about, but they're coming on the parent's insurance, and they go in and fudge the records. That's actually happened. So you want to make sure that you have policies and procedures in place to avoid that type of thing as well. And then transmission security. You want to make sure that EPHI cannot be intercepted while being transmitted. Now, I actually had a conversation about this, I believe, on Wednesday with someone who stopped by my table as well. You hear all this talk all the time about encryption, encryption, encryption. Encryption is not a requirement under HIPAA. A lot of people use encryption, and we recommend encryption because it really is the best way to prevent these types of things from happening. But if you don't have the capability to encrypt everything that's electronically transmitted, you don't have to necessarily worry that you're not in compliance with HIPAA. It could just be as simple as uploading a PDF document with a password protection on it, emailing the document, and then sending that password regular mail or calling on the phone and giving the password on the phone. That's not encryption, but it is password protection and it is sufficient to secure that transmission. Physical safeguards, that's usually pretty intuitive. Facility access and control. Everybody in your staff doesn't necessarily need a key. Access cards, alarm systems, things like that. And workstation and device security. If you do have laptops, lock them. People shouldn't be taking them home unless they absolutely need to and it's completely unavoidable. Policies and procedures for disposal of old technology. That's a big one. A lot of time, I mean, you can't just throw the old desktop in the dumpster when you're done with it. A lot of shredding companies, though, now a new service that they do offer is electronic wiping. And actually, I personally just got rid of a work computer, and I think Staples actually offers that service as well. They'll wipe everything for you. And then workstation device security, wiping for, the last part of that is remote wiping for smartphones and tablets. I actually used to work with an attorney who was walking down the street in New Orleans, and somebody went past him on a bicycle and grabbed his phone. It was his work phone. He took his personal phone out of his pocket and called our tech support company, said, "My phone just got stolen, wipe it." And the whole phone was wiped in a matter of minutes. And again, there are organizations that provide that security. We just had the big issue with Apple and the FBI. If you have an iPhone, lock it and set it so that the entire phone is wiped if the passcode isn't achieved in a certain number of tries. Has there been a breach? Okay. This is your breach analysis. You have to conduct an assessment to determine if the question is a breach. And the following items have to be considered. This is your four-prong test. The nature and extent of the PHI involved and the likelihood that the patient can be identified. The unauthorized person or person who received or accessed that PHI. Whether it was actually accessed or viewed, and to the extent to which the risk has been mitigated. So for one example of it's not a breach, okay? You accidentally sent a patient record to the wrong email address and it wasn't password protected. The person who receives it immediately calls you up and said, "I got the wrong patient record, I deleted it, I just wanted to let you know so you can send it to the right place." That's not a breach. There's a very low likelihood that it was viewed. There's a very low likelihood that it's going to be used. The person called you up, they said it's deleted, don't worry about it, I shredded it. That's why a lot of times on the bottom of the fax cover sheets you'll see a little legal disclaimer that says if this was received in the wrong place, please immediately shred it and call us. That's to try to minimize the potential that there was actually acquisition or viewing or use of that record. And if the covered entity determines that it was a breach, then they have to notify individuals, the Secretary of DHSS in some cases, and in some cases the media. That's when you'll see, for example, the big Blue Cross Blue Shield in New Jersey breach. It was a few years back now, I think. One of the workers brought home a laptop, and the laptop was stolen out of the car. You saw that on the media because it affected over 500 individuals. For all breaches, there is notification to the individuals within 60 days of discovery. You can send them a letter. If you don't have sufficient contact information for 10 or more people that might have been affected, then you can achieve this standard by posting a notice on your website, in the local newspaper, something like that, and then setting up a toll-free number where individuals can call and find out they were affected. And that number has to remain active for 90 days. If you have fewer than 500 individuals affected, you still have to notify the secretary, but that notification is only required within 60 days of the end of the calendar year in which the breach was discovered. So let's say a breach is discovered tomorrow. You don't have to report that breach until 60 days after January 1, 2017. If more than 500 individuals are affected, notification to the secretary is required without unreasonable delay. That basically means you really should tell the secretary right away, but no later than 60 days after the date of discovery. What I typically advise my clients or potential clients is call your attorney first, call your insurance carrier first, because there are insurance policies now that will cover whatever expenses you have from a HIPAA breach or an electronic data breach. And speak with them first, and then make a plan as to how you're going to advise the secretary. And then again, more than 500 individuals affected, notification to the media is required. Business associates, we're getting to the end here, and we've discussed this a lot more at length at the beginning, so I'll go through this a little bit quickly. What is a covered entity? That's any provider. Health plans or a healthcare clearinghouse. A business associate is any person or entity other than a member of that current covered entity's workforce who performs services. Okay, and again, that change under omnibus rule, it includes subcontractors of business associates. Who is not a business associate? Anyone who provides services that do not involve access to the protected health information. So like I said, that's the person who cleans your office. It specifically excludes the U.S. Postal Service. Even though the U.S. Postal Service is carrying tons of mail with patient information in it, they're not accessing it, and they're not using it, and they're not looking at it. It's a federal crime for them to open your letters. So the U.S. Postal Service is specifically excluded. Business associate agreements. Now, again, I think there were 1 or 2 hands when I asked who knows what a business associate agreement is and who has them with their contractors. Again, this is all written out. I'm not going to bore you by reading it to you, but the basics are it's a written agreement between you and your business associate, and these are all of the things here that you need to make sure in that agreement. The most important things, and again, if I am reviewing a business associate agreement on behalf of a business associate, I'm looking for different things, and I want different things in there than if I'm reviewing it on behalf of a covered entity. If you are doing business as a contractor with another covered entity, they're already obligated under HIPAA. You don't need a business associate agreement with them. This is purely for contractors who are not also covered entities. Okay, and then part of what your business associate agreement has to require is that your business associates have a written agreement between themselves and their subcontractors if any of those subcontractors are working on the work that your business associate is doing for you. And again, these are all the requirements that have to be in that document. Business associate subcontractors, who are they? Same analysis to determine if someone's a business associate would be the analysis you would use to determine if they're a business associate subcontractor. Okay, and business associates are typically required to have these similar written agreements. I say typically required to have them. if I were representing the covered entity, they would absolutely be required to have them. And they would absolutely contain all of the same obligations that the business associate has to the covered entity. I would want that subcontractor to have. And if anyone has any questions, and please, I'm actually in the process of moving. So the address is correct, the phone number is wrong, but my website will always be the same, and my email address will always be the same. So if you do have any questions after you leave here today, please don't hesitate to email me. I'm always happy to answer questions. But if anyone has any questions now. Yes?
So can you give an example of one of these instances where authorization is required?
I'll repeat it, it's okay.
Basically, like for the authorization and use of disclosure for marketing purposes, that was a little...
Okay. A use and disclosure, and yes, that is, there are very specific, the question was, can you give an example of when a use and disclosure for marketing would be required? That would be, you have, for example, a large hospital system that wants to market a new product or service that does not necessarily have to do with what that patient is being treated for. For example, you have a lot of hospital systems now that are opening up their own health clubs or things like that. So if they want to market membership into that health club with patients, it really, most of the time, it really doesn't have anything belonging to that particular health club unless the person needs physical therapy or something like that, which even that would be a stretch. Doesn't have to do with what they're being treated for. So you would need a disclosure for marketing for that. There are specific exceptions, though, which clear it up a little bit. A refill reminder from a pharmacy is not marketing. Promotion of services that the patient actually needs or could find helpful for their treatment, that's not marketing. So again, that would be the recommendation to the physical therapy provider or something like that. If somebody just had knee replacement and you want to say, hey, there's a physical therapist right in your town, they're great, that's not marketing. And anything where there is only nominal compensation to the physician or the practice of the provider that only covers the cost of notification to the patient, that's not marketing either. If you're making a profit off of notifying the patient about a particular drug or therapy or treatment, then that's marketing. So it's very, I don't think that cleared it up much, but
I don't understand why they're having to sign a release if you're talking about marketing for
right.
a service. Why would you be releasing any of their information in the purpose of marketing?
It would be in that scenario where, and I agree with you, it's rare and it's few and far between because most providers, what they're providing is not marketing. So that's why you have those specific exclusions like refill reminders from pharmacies and things like that. But then you might also have something coming out from a pharmacy that's like, hey, try our great new product that's over the counter. That would be something that, when everybody signs for their prescriptions, they don't read what they're signing. They're typically signing something that says, hey, yeah, you can email me and advertise other products. So it doesn't really apply to primary practice providers as much as it does to those other types of covered entities.
And then the second question real quick,
Yes.
What about patient sign-in sheets? There's been a lot of debate about patients come into the office, they come up to the window.
Yes. Do not use patient sign-in sheets.
I see them in dental offices
yes.
all the time.
I go, every single doctor I go to, I literally sit in the waiting room and just make a list of all the problems in my head, and it's become very difficult for me to go to the doctor without doing those things. Patient sign-in sheets are bad because you basically, you have someone coming and signing in and they can see every other patient that was there that day. Just disclosing that someone is your patient is a violation of HIPAA. And I agree with you, they're used everywhere. But I would never get medical care if every doctor I went to, I was like, by the way, you have these 5 HIPAA violations in your waiting room.
Realistically, if they're reported, they're just as much in trouble as we would. That's a violation, and we as patients don't like it and report them, they're potentially in trouble.
Are you talking about the provider? Of course, absolutely, absolutely.
I mean, because apparently they just keep doing it. I don't understand how they're getting away with that.
It's because in the past there have not been random inspections, which now HIPAA is becoming a hot topic now because now OCR has really gotten has really gotten in a lot of trouble because they have not been performing inspections and they have not been enforcing HIPAA the way the government feels that they should. So I think we're going to see a lot more inspections like that without complaints. Yes.
As a primary, we have patients who go to a lot of specialists, and I have a problem getting information from the specialist. Some certain specialist office where we'll call, can you send us the lab results? And they give us a hard time saying we can't HIPAA, we have to get a signed authorization. And I was under the impression that patient, doctor to doctor is not a HIPAA violation, but a lot of these offices give us a hard time getting information.
You're not alone, but you're also correct. If it is, that's that treatment or healthcare operations exceptions where authorizations are not required. Your primary care, you send your patient to a specialist. You need the report from that specialist in order to continue your primary care. No authorizations are needed back and forth to share information between those two practices. The follow-up was, how do we get those offices to understand that? And I'm sorry, I have no good answer for that. You can feel free to give them my number. Yes.
The ERISA laws were about 10 years prior to the HIPAA laws, is that correct?
I believe so.
Okay. The question I have is, will the insurance companies be able to access the patient's record through the patient portal and still be protected because of HIPAA? There's no problem with that, is that correct? In other words, they can do an audit in real time based on the ERISA laws instead of coming to my office and looking at the computer or a chart document. That
is one of the concerns that a lot of providers have had about interoperability of EHR and availability of patient portals on the internet. If your patient has authorized their insurance company to look at their record at any given time, then yes, they can absolutely do that. And typically, by virtue of paying the premium for the insurance, they've agreed to allow the insurance company to do that.
And they can do that through the patient portal?
With the theory that the patient has authorized them to do that.
Okay, thank you.
Hi. I
Hi.
have a few questions. Let me just give them to you, and you can answer whatever ones you want.
Okay.
If you work for another facility, you're a contracted physician, or in some other way work for a facility, are you still the custodian of the records? Number two, if you
I'm sorry, are you still what?
Are you still the custodian of the records? So I'm the custodian of the records. If it's my practice, if my practice is subsumed by another large organization, Evil Empire number 2 or 3, am I still responsible for those charts?
Okay, that's actually a short answer, so I'm going to stop you there so I don't forget the question. You are, unless you enter into an agreement with the purchaser or the new facility, that they will be the new custodian of the charts. And part of that agreement is they can't use or look at those charts until the patients come in to see them and sign an authorization which says that they can. And this is, I've dealt with a lot of transactions where my clients have sold their practices to Evil Empire 1 and 2, particularly in the state of New Jersey. And you just want to make sure that you have that agreement in there that, okay, you know, the dark side is going to take all your charts, and all your patients will know that that's where their chart is, but that the group is not allowed to access those charts. They're not allowed to start opening them up and calling patients and asking them to come in and make appointments. But that would relieve your obligation to be a custodian of those records.
Physical protection. HIPAA talks about locking the cabinets. If you have a room in which the cabinets are located and that room is locked at the end of the night, is that a sufficient physical?
I would consider that sufficient, yes.
Okay. Now, a lot of us do provide medications for psychiatric disease. Is that psychotherapy? Do we need a separate authorization if we're not doing psychotherapy, but if we are talking to the patients about psychological illness?
No,
Good.
no.
Okay. If a doctor is requesting charts, but they're unreliable and they lose them, can we send the chart to the patient, say you take care of it, we refuse to send to the doctor, but we're sending it to you?
Generally, you have to send it wherever the patient wants you to send it. You can suggest to the patient, I would prefer to send your chart to you because I've worked with this physician before, I've worked with this practice before, and I've had concerns with them losing patient charts. And then it's up to the patient to say, okay, fine, I'll take my chart. But if the patient says, no, I don't care, send it to them, then you're obligated to send it where the patient wants it to go.
Okay, last question. Is a lab or a pharmacy an entity with whom you have to have a business relation since they are also covered entities?
You mean a business associate agreement?
Correct.
No. You do not have to have a business associate agreement with a pharmacy. And a laboratory is also typically considered a covered entity as well.
I got two questions for you also.
Sure.
If there's any special situations or training a student, medical student, et cetera, anything that you have to worry about, them looking at patient charts, et cetera. And the second question is a lot of times filling out notes for work or school or something. Any special situations there?
Let me just make sure I understand the question. Are there any special situations I've come across with regard to training of students?
Well, I take a medical student from my office to the hospital, to the nursing home. They're looking at charts, looking at patients, anything that they need to sign or take responsibility for their behavior, or is it all on us?
They
I mean,
would
how
be
is this
they would
treated?
be considered a member of your workforce. Like you're talking about a student that's your intern or something like that?
Yeah.
Yeah, they would be considered a member of your workforce. So you would not need any special documentation with them. If they were coming to you, if you have another physician or provider that's coming to you as an independent contractor, not a W-2 employee, which that has its own issues. You can't just say someone's an independent contractor, so I'll just put that caveat out there. But if they're truly an independent contractor, then you do need a business associate agreement with them.
Okay. And then what's the situation with, you have to write an excuse for, maybe at court or for schools or for work? Mm-hmm. What should you put on these notes? Should you keep it ambiguous for their excuse notes, et cetera?
If the patient requests the note, then that's the patient saying, I'd like a note, and then the patient's giving the note to the recipient. So you're not disclosing anything to anyone except the patient.
What about for courts and whatnot?
For court, okay,
Jury duty
I actually
excuses,
get that a
et
lot. For court, you want to be very careful. A lot of people, and a lot of times I'll have my clients call me and say, oh my God, I got a subpoena today for medical records. I can go print out 15 subpoenas in my office right now and just send them out with a PDF of the signature on them. And no court ever actually saw that subpoena. A subpoena is not sufficient. You need a court order or an authorization to release records for litigation. If you do not have a court order and you do not have a signed authorization from the patient, do not give them anything. I don't care what they say to you or what they threaten you with.
Is that more like when you have to write duty? Is there a notice on there?
I would keep it as vague as possible. Just, patient can't appear because of medical reasons. But again, you're only disclosing to the patient. And then they're taking that note to whomever and giving it to whomever. So that would be no different than the patient saying, hey, I'd like a copy of my records. And if the patient wants to go make posters out of their medical records and, hang them up in Grand Central Station, that's their business. Right. Yes.
I have a question about liability with, for example, we have an answering service, and I know we have a business associates agreement with the answering service.
Yes.
But now I'm thinking, we get messages that come through in text form on our phones about patients and
Right.
like locations in hospitals and why they're there. So what is the liability of that patient information coming through on a cell phone?
That's when you want to, as much as it's reasonably practical, keep your personal and your business separate. If you see me walking around, I have 2 cell phones. I usually have one in each hand. One has text from my mom on it saying, are you alive? Where are you? The other one has emails from my clients on it saying, are you alive? Where are you? To any extent that you can, keep personal and business separate. And then with business, you want to make sure that you have password protections on that phone. And I'm not talking about 1234 or, you know, your dog's name. I mean, real password protections, the thumbprint, which if you can get it to work, I'd love to know how. Things like that. And you also want to make sure that it can be wiped if it's ever lost or stolen.
I mean, any issue with the phone company itself? Do we need to?
No,
That
no.
information going through, like,
They're kind of in the
Verizon?
same category as the Postal Service. They're
Okay.
just a transmission medium.
Okay.
Yeah.
How about in reference to chart reviews for studies?
Okay, that would be, the question was in reference to chart reviews for studies. That's a specific category, which is for research. And that's a little bit, I don't even really touch on it in the 1 hour overviews because it's usually such a particular situation. Most of the time, you're using de-identified patient information, which basically means all identifying characteristics are stripped from that information. So as long as you have, and I am blanking on the academic authority that approves human research. Thank you, IRB. As long as you have IRB approval, then you're fine. You don't need additional approval from the patients. But if it's something where you do need to identify the patient, then you would need approval. But 9 times out of 10, it's an IRB-approved study with de-identified information, and you're good to go. Okay, last one.
Actually, it's a multiple part question, so.
Okay,
kind of one last
let's see how we
question.
do.
In dealing with our equals, AKA pharmacists who demand a diagnosis or a diagnosis code before they will fill a prescription, or better yet, pharmacists from Walgreens who demanded copies of the medical record without having a safe place to store them before they would fill a prescription, which directly affects the treatment and health of the patient. What are our obligations, protections, and options?
May I ask what state you're in that the Walgreens are requesting that?
The evil state, the People's Republic of New Jersey.
Really? Wow, that's the first I've heard of that.
Well, it's about a year old now. They actually got smacked real bad, and they're not doing it, but they were caught with a secret checklist of whether they would prescribe any controlled substances or not. They denied
Oh, I
it. They
see,
got-
because
yeah.
it goes to controlled substances, yeah.
But medicine is medicine.
Right, exactly. I agree with you that it should not, once the physician makes a determination as to what the patient needs, the pharmacist's responsibility is to abide by that determination and get the patient their medication. You have no obligation to send patient records to a pharmacy. If you are ever asked to send patient records to a pharmacy, then I think the best way to combat that is to say, I'm going to need a written explanation from your legal department telling me why I'm required to send patient records.
And if I had the option with a patient on controlled substances to send them to another pharmacy, I would. But because of FDA regulations and now percentages of medications filled by pharmacies and limitations, it's not an option. If you piss off a pharmacist who is willing to give your chronic pain patient controlled substances, they're not going to find another one. We're in Northwest New Jersey, so it's no plethora of pharmacies.
Yeah.
But what I see more often with even my family patients, they want me to put the ICD-10. I usually respond, damn it, Jim, I'm a doctor, not a coder, and it flies over their head. But I have had pharmacists refuse to fill scripts without me specifying whether it's sinusitis, bronchitis. I mean, it's intrusive. I think it's illegal, but what can I do?
You can say, I would like a written explanation from your legal department as to why I'm obligated to do that.
Well, and they'll just say, find a new pharmacy.
Right.
What I did do with Walgreens is I made them send me a HIPAA-compliant records release signed by the patient. That really took care of the problem.
Yeah, I was going to say, if the patient is willing to sign a release, sometimes, and again, this is actually another conversation that I was having with someone on Wednesday, there are bigger forces at work here that I think neither the patients or the providers or the physicians are benefiting. There's a bigger force out there, so I think that patients can really be the best advocates for physicians. It's one thing to have a pharmacist calling you and telling you have to do something, but if your patient is standing there in front of the pharmacist saying, what right do you have to, and especially in Northwest New Jersey, I mean, that pharmacist might be someone's neighbor. that they don't want them knowing why they need that medication. It's none of their business. You know, and again, they have the same privacy obligations, but still, you know they know. And a lot of people that live in more rural and less populated areas, they really don't have the choice to not go to their neighbor that knows their parent or something when they need a medication. So I think that, you know, encourage your patients to be their own advocates with the pharmacy. But I think exactly what you did, if you're not going to get anywhere by arguing with them, exactly what you did is the appropriate thing to do. Tell them, send me an authorization, I'll give you whatever you need. Okay? All right, well, thank you very much. I appreciate you having me. And if anybody thinks of any other questions, please, like I said, don't hesitate to reach out. I'm always happy to answer a question. Thank you.